Corporate rescue is one of the formal insolvency remedies available to businesses under financial distress in Zimbabwe. For directors, this option is critical. Why? Because their decision to commence proceedings or not often determines whether the business survives or fails. I am Calverwell, and I help SMEs manage restructuring and create the clarity they need to grow with confidence. In this session, we'll explore directors' obligations, risks, and personal liability under the Insolvency Act. Corporate rescue places the company under temporary supervision by a corporate rescue practitioner. During this period, the practitioner develops and implements a rescue plan. All legal proceedings and enforcement against the company are stayed, and property lawfully in the company's possession is protected. These three imperatives, supervision, moratorium, and rescue plan, form the cornerstone of corporate rescue. For directors, this matters because their legal duty is always to act in the best interest of the company and its shareholders. That duty does not disappear in financial distress. In fact, it becomes even more important. The Companies and Other Entities Act spells out directors' duties. Part 4 highlights the duty of care and the business judgment rule. Directors must act with skill, attention, and diligence, as any reasonable person would in the circumstances. The duty of loyalty and disclosure of conflict of interest. Directors must avoid using company resources for personal gains and must disclose any conflict of interest. Section 218 also sets out specific responsibilities. These include formulating and implementing company strategy, financial reporting, human resource management, convening shareholder meetings, and deciding on securities to be issued, whether equity or debt. When applied properly, these duties act as early warning barriers against the collapse of a company. Before commencing rescue proceedings, directors must carefully evaluate the company's prospects. Only companies that are financially distressed and have a reasonable prospect of rescue can enter corporate rescue. Corporate rescue is not for the terminally ill. Once directors decide that corporate rescue is appropriate, they must pass a resolution and file it with the Master of the High Court and the Registrar of Companies. The resolution must be adopted collectively to avoid dissenting directors disrupting the process. Once the resolution is filed and a practitioner is appointed with a certificate of appointment, the board of directors is deemed dissolved. From this point, the Insolvency Act transfers all duties and responsibilities to the practitioner. Directors may only act when specifically instructed by the practitioner or permitted to perform certain management functions. They must also provide full cooperation by supplying requested information and assisting with investigations. This cooperation builds trust and helps secure stakeholder confidence. Without it, the proceedings risk being challenged by affected persons. Remember, directors know the business best. They know the contracts, they know the liabilities, both on and off the books. It is in their best interest to disclose all material information to the practitioner. This ensures the practitioner can assess viability accurately and develop a realistic rescue plan. If the rescue plan is implemented successfully, directors are reinstated with full powers. They continue leading a solvent, restructured business. If not, the practitioner hands the company to a liquidator for winding up through the courts. The success of corporate rescue depends heavily on directors understanding their role. Before rescue, they must apply their duties diligently. During rescue, they must cooperate in good faith, and after rescue, they must rebuild with integrity. If your business is facing financial distress, do not wait until it's too late. Seek professional advice, explore your options, and secure the future of your company.